We begin with the ongoing lawsuits between Disney World and the state of Florida regarding control of what was the Reedy Creek Development District, and also, of course, its impact on the park and the private entity that is Disney World. Disney World, of course, has previously sued DeSantis, and now DeSantis is suing Disney World in this continuing lawsuit over control of the district, the governmental entity that is the district, and also its impact on the private entity that is the park. So we have two forces that are involved in this, the governmental entity and the private entity, and their interrelation there too. So we're trying to continue to do this, and now DeSantis's board has filed suit against Disney in response to Disney's suit against DeSantis. So fun and exciting times there for sure. The district board that is now in control of this area has filed suit in state court escalating the lawsuit. The 188-page lawsuit asks the courts to render void and unenforceable the grant that Reedy Creek granted to Disney World just before Reedy Creek ceased to exist. So one of the last things that Reedy Creek did was create this grant, this contractual grant of power to Disney World to basically try to transfer all the governmental functions effectively to Disney World so that Disney World would remain in de facto control of the district, even as the government tried to take over. And so now they filed a lawsuit saying, okay, this grant, this contract, this paper you put together is not worth the paper it's put it on. So the lawsuit specifically targets the arrangement set up with the board in which the company tried to invoke property law and then said, okay, this will be in place at least until the last heir of King Charles III dies, trying to get around rule of perpetuities problems. So it's like, okay, forever or until the last heir of King Charles III dies to try to make it against rules against perpetuities. But of course, that isn't the only issue in play here. There are more underlying issues than that. The agreement, if it were valid, would give Disney control over its land effectively forever or close to it. So that's what they tried to do. And of course, well, maybe they shouldn't be allowed to do that. The countersuit comes after Disney sued the governor and the board, alleging DeSantis and his office have engaged in a targeted campaign of governmental retaliation against Disney that was orchestrated as punishment for Disney's speech. And we've tried to talk about this a little bit before because things get very legally complicated in this domain. Because we have two entities in play. We have Reedy Creek Developmental District and Disney World. These are distinct things. There is no dispute that they're distinct things. Their interaction with one another is, of course, where things get interesting. It would be like saying that Orlando is distinct from Disney World, or the state of Florida is distinct from Disney World in that same sort of way. But of course, Orlando or Disney World or Reedy Creek or whomever it might be that's trying to impose on Disney World to the extent they're trying to impose on a private entity, then you have potential issues. So government gonna government, but when they do things against private entities, particularly if they're done in a way that is a violation of constitutional protections like First Amendment issues, you might have issues. But the thing gets complicated, of course, on a whole bunch of things. You have to go back to the original grant of power to the board, to the district. You have to go back to the original grant. You have to go back to the mechanisms by which Reedy Creek attempted to give notice about this and whether or not they gave effective notice and whether or not there's a whole bunch of legal issues in play, as I'm sure you can appreciate, in trying to undo this relationship to some degree. The chairman of what is now called the Central Florida Tourism Oversight District, because they gave Reedy Creek a new name. So it's no longer called Reedy Creek. Now it's called the Central Florida Tourism Oversight District, which I'm not really sure is a great name for it, but whatever. The chairman of the board says they have no choice to respond. We will seek justice in state court. We will seek justice in our state backyard, and all 5 board members support the motion, which makes total sense. I mean, they're appointed by the government. They're appointed by the governor to do the will of Florida. they are Florida legally because only Florida has sovereignty. And so, yeah, they want to respond to this. And some of this, at least, is a matter of state contract law. So a lot of this is state law specific. In fact, most of this is state law specific. Most of this gets into issues about how the district is created, how districts are dissolved, what kind of notices they have to give, what kind of control they have from the government, from the governor's level, right? So almost all this is state law specific. The contract itself, whether the contract is valid from first principles, is a matter of state law. Contracts are state law. So almost all this is state law specific, with a little bit of First Amendment retaliation thrown in potentially, and maybe some equal protection if we're putting our thinking caps on. But yeah, this is principally state law. So state courts are principally where this would go. The choice by the board to file the lawsuit in Central Florida stands in contrast to Disney's decision to file in the U.S. court. So Disney thinks the First Amendment issues are principal and therefore wants to file in federal court. The board, for its part, wants to file in state court. So that's fun. In an interview with the British newspaper, DeSantis accused Disney of foreign shopping for a judge who rules against them, which, to be sure, yeah, I mean, you're going to try to find the judge who is most likely to rule for you. Everyone does it. So, yeah. DeSantis, of course, is likely to launch a presidential campaign at some point in the near future. So this might relate to that as well. The board oversight overseeing Disney's districts has met 4 times and hired attorneys and financial advisors as they consider changes to the self-governing privileges of Disney. They've also started a search for an urban planner and economic consultant because, among other things, they would be responsible for the roads and how those are built. And there is quite a lot of traffic around Disney World. So there's a lot of interesting issues there as you try to plan out the space and the interaction with the space. On Monday, Garcia expressed frustration about Disney's escalation. In essence, Disney is asking the federal court to wrestle back hands of time to 1967, when this board was initially created, instead of changing it with the 21st century practices. Disney is also having some financial problems. They've been having layoffs recently, which could be due to a whole bunch of reasons, including potentially their movies and people not particularly liking them as much as they used to. But Disney also has announced plans to invest heavily financially in Disney World to the tunes of billions of dollars. So mixed messages there from Disney corporate. Under a decades-long agreement with the state, Disney doesn't have to run its plan by zoning commissions or building inspection departments. Well, that's kind of true. More to the point, they had to run it by Reedy Creek, and they were Reedy Creek. So they had to get zoning commission and building inspection from themselves. So, that kind of made it easy. DeSantis' new board said nothing's off the table as it took to major overhaul the areas. In the mix, possibly higher taxes, regulations, something dealing with the workforce housing, which has long been a point of some interest as Disney, how they house their own staff or lack thereof has been an interesting issue over the years. And exploring the sale of utilities that the district owns because they generate their own power, because they use a lot of power. So they generate their own power. And so maybe we could sell some of that power to other parts of Florida as well. Asked about the lawsuit during an unrelated press conference, the governor said it was wrong for one corporation to basically corrupt the local government, run it their own fiefdom, which that's not a completely inaccurate description of Reedy Creek, be exempt from laws and have all kinds of benefits. Disney had a lot of power over this district. It's not the only special district in Florida, but is arguably the most powerful special district when it comes to private control over things. So Disney World, I think, had more control with respect to its local district than pretty much anyone else. So it's not exclusively a Disney thing, but Disney definitely took it to its limits and definitely was using it for its maximum advantage. Thus, that brings us to the end of the discussion for the moment about the ongoing lawsuit as it relates to Disney versus Florida, as it relates to the Reedy Creek Development District or the Florida Oversight Tourism District or whatever we're calling it today, which is definitely a governmental entity, and its interactions with Disney which is definitely a private entity. For 50 years, the governmental entity and the private entity have been somewhat indistinguishable, although legally distinct. And so now we're trying to sort of undo that. And that's raising all kinds of fun and exciting issues. So I think on balance, as I've said before, I think on balance, Florida has the better end of most of these arguments because they have control over their own districts. And to the extent that Reedy Creek was trying to give power to Disney, it looks like self-dealing and raises some serious interests under Florida state law. The thing that comes immediate to mind is just unconscionability, as it's void for public policy. The contract is void ab initio because what's it fundamentally attempting to do is devolve a governmental entity's power into a private entity in a permanent way. And that probably can't be possible because that wouldn't make any sense. If you give governmental power to a private entity in a way that you can't crawl back, that sort of fundamentally violates the nature of what governments are, because now a private entity is the government. And that's really, really weird. I think on balance, Florida has the better end of most of these arguments, but it'll be interesting to see how these cases resolve as they go through the various courts, both federal and state, with potential conflicting decisions. I'm sure as we escalate this for what will be a year-on-year fight, I have no doubt. And that, for the moment, brings us to the end of discussion of that story.